Little technical difficulties there, but we are back. And you guys just heard from the real elf. Shouts out to Tommy for that. We want to keep this thing moving along. What else do we have here, man? Please hit that like button for the YouTube algorithm as well as hit that subscribe button to be a part of the IP community. Let's talk about what Disney has going on. I just took my daughter to the Disney on Ice in Grand Rapids, Michigan earlier, or last week, I should say. It looks like Disney has filed for a patent on more or less a new ride. So let's kind of pull that up and see what it is that Disney is talking about. And man, let me know where you guys are from. And if y'all got an IP question, let me know in the chat. This is probably the first time that you're going to have a be able to talk to an IP attorney. The boy billable rate is almost 400 an hour. So that's kind of Disney files for a new patent on an articulated arm ride that could change how attractions work. So typically you see it look like this is a motorcycle or something, but you see the person here 102 and it's an arm rod and it's going in a circle. And typically the arm rod is just kind of going in a circle, maybe at varying speeds, but it seems like Disney has filed for a new patent that allows that I guess being that you're in to move in a lateral direction. So you see here 102 to the right, but it also moves to the left, essentially moves along this arm 104. So it seems like Disney has filed for that new patent. So kind of be on the lookout for that ride. You can see here this kind of bend or this carriage 102 that is able to move along this arm 104. Seems like that's something that Disney has kind of worked or has been working on. So you may be you may see that at Disney World here. Your boy probably going to go on another Disney cruise this summer. I'm not sure the next time I'll be at Disney World, man. I done took my daughter there a couple times already. So the arm is connected to a chassis that runs along the track. As the chassis moves, the arm adjusts in real time. This means that the ride vehicle can be repositioned laterally, essentially side to side, vertically up and down, or both simultaneously. So again, ultimately, this arm can go up and down, but it all can move side to side. So that's the new ride. You would thought that they would have did that before, but essentially, this is new stuff. And I will say, man, when you have a ride like that, there's a lot of things that you got to account for when you're talking about the weight, talking about the speed, talking about the weather. So it's a lot as opposed to just kind of moving something back and forth. To be able to do that safely and still kind of get the effects that you need to get the effects of while the rider. Apparently that's something that Disney just kind of cracked the code for. That said it was worth filing a patent application. They filed it for it this year, or it was published this year. So typically a patent application publishes 18 months after you file it. So if it published on January 29, 2026, it was first filed 18 months, so 2024. Well, like July of 2024, I would imagine July 29th. Oh, there you go. Filed July 24th for 2024. I told you. So again, Disney just filed for this new patent. Be on the lookout for that at Disney World. I would imagine that they're going to update at least some of the rides on this one. So let me know what you guys just think about that. Again, Disney files for a patent for articulating arm ride system that could change how attractions work. So gotta be on the lookout for that, man, as things move forward to the extent that you guys go to Disney World. Let me know where you guys are from in the chat section or in the chat, man. If you got a question on intellectual property, like I said, I just purchased the assets to this trapdoor calendar. So be on the lookout for that. What else do I have coming up here? I did a interview with Ray Sean, and shouts out to even Tommy, who said that he ended up getting into the real elf. That interview just came out. He said he got off into that on accident. And I was talking to Ray Sean, who has screen skins here. I don't know why my phone always do this, but you see the Michigan State logo. I'm a big Michigan State guy, and you see the screen protector. Your boy sent me a couple of these. So you got the Michigan State logo that kind of as your phone is off, and then when you what's name, it goes away. So he actually, and I didn't know this, the interview gonna come out in like a couple of weeks, but I didn't know Ray Sean screen skins. It was just on Shark Tank a couple of weeks ago. He's Maurice Clarett nephew. So this is how crazy this stuff is. Maurice Clarett is on a podcast. So he's interviewing the guy who came up with the original idea. Maurice Clarett picks up and calls Ray Sean like, hey man, you need to get with this company. So next thing you know, Clay, who's the original founder, and Ray Sean, who's a co-founder, they come up with this company, Screen Skins, and the rest is history. But it was all based on kind of a call from his uncle and football legend at Ohio State, Maurice Clarett. So man, that interview was, it's a dope interview, and be on the lookout for that one comes out. It should probably come out in a couple weeks. But again, man, this stuff, hey, man, this AI is going to come for us all at some point. So you might as well kind of get off into the game with products and just try to get something out in the market to sell. And I think the journey really is the beauty of it, man. I think that's for me. When you're talking about starting a company, building a company, or doing something, you got to appreciate the journey. So shouts out to Screen Skins, which is going to be out. But let's kind of move on to Taylor Swift here. Taylor Swift, hit that like button for the YouTube algorithm as well as hit that subscribe button. Let me know where you guys are from too as we pulled up. We just talked about Disney. Seems like Taylor Swift. I'm not sure if any of you guys are Swifties that are watching this. It seems like she just sued somebody for trademark infringement or forced somebody to essentially stop using her name. So you see down to the left, Taylor Swift. Kind of pull it up here. Come on, man. Come on, here we go. So Swift Home. So somebody was using the term Swift Home, and it's a big company. The company who was using it, I forget the name of it. I did a full video. This is a kind of a quick hits. But the company that was using the term Swift Home, they selling Nordstrom's. They selling, I think, Neiman Marcus. So this is a bedding company that sells pillows, mattresses, sheets. But they kind of some big dogs. And Taylor Swift, who has her trademark, man, Taylor Swift has almost 200 trademarks. I was looking that up. Like, Taylor Swift understands protecting the intellectual property. And so she has 200 trademarks, one that being her name. You see the name on the upper box of the picture in the left-hand corner, Taylor Swift. And Swift Home, she essentially made them stop using the term Swift Homes for bedding, for mattresses, pillows. I think Class 24 is the name or the class that was relevant because she thought it was likely a confusion. And this is a good way to use on both sides of it, to be honest with you, the intent to use. So when you file a trademark application, you can file an actual use application with saying you telling the USPTO, hey, I'm actually using this mark in commerce, or you can file an intent to use application with saying, hey, I'm not using this mark right now, but I intend to use it. Therefore, I want to protect it. Seems like the company who owns, who was using the mark Swift Home, they filed an intent to use trademark, and Taylor Swift saw that and essentially opposed the mark. And at that point, the company, man, let me see, who was the company? Kathy Home is a company. They pretty much like, look, man, this is not worth the headache. So they stopped using the term Swift Home. So it's a win for Taylor Swift, but at the same time, it is also a win for Kathy Home because they didn't spend the money on marketing and manufacturing the product. It was just an intent to use trademark. So they got what, $1,000, $1,500 in a trademark application. And when Taylor Swift opposed the mark, they just simply, they washed their hands with it. Matter of fact, I'm gonna go to the actual thing. What did he say? I'm gonna go to the what did the owner of Kathy Home say? Okay, our client has not used this disputed mark in commerce. Kathy's attorney said, after evaluating the circumstances, our client elected not to pursue registration of a mark it did not consider essential to his business. So again, this is a good way to actually do this. Even though Taylor Swift ultimately won, I think Kathy Holmes, the attorney, I mean, it's a win for them. They saying, look, we not using this mark in commerce, and after evaluating our circumstances, this shit ain't really that essential to our business. So as opposed to kind of going through a back and forth for a lawsuit with Taylor Swift that can cost us tens of thousands of dollars, hey, we just gonna wash our hands with this. We not even gonna use it. So, man, shouts out to really not only Taylor Swift, but shouts out to Kathy, because I think this is the way that the trademark system should operate. You start using a mark. I think they even filed for a trademark on it. Somebody opposed the mark. In this case, Taylor Swift opposed the mark. We all know who Taylor Swift is. And Kathy, like that, Kathy Holmes, the owner of the mark, they're like, man, this is not that important. So we just gonna wash our hands with it. And a lot of times we go through these cases, and we'll see here in a little bit where companies are spending tens of thousands of dollars on marketing materials, on manufacturing a product, only to be forced to do something different. And that's not what you want. So, man, shouts out to Taylor Swift and kind of her team. But I do also want to shout out to Kathy Holmes, because I think what they did was important as well. So let's go to Nike. Nike said they tired of y'all having these fake Jordans. They tired of y'all of selling these fake Nikes. And one of my kind of football compadres I was talking to a couple of weeks ago, back in our college days at Michigan State University, hey, people were just selling the fake Jordans. And they had them on campus. They selling them for $40, $50. And obviously we know real Jordans going for $150, $200. And it seems like Nike is putting an end to that with their latest patent. I'm kind of try to pull this up here, man. Let's try to pull this up. And as I pull it up, that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community. Doing some big things over here. So here we go. There we go. So this is Nike's patent. It just got issued. So this is actually a real patent. So it's 12,499,456. It was just issued last year, late last year in December. So essentially what Nike is doing, and this is the claim to the patent. Let me see if I can kind of blow that independent claim up. You see the claim 1 is a method of authenticating an article of clothing. So essentially Nike is using a blockchain technology to authenticate whether it's shoes, whether it's other clothing items. They're using a machine readable identifier on the exterior surface of an article of clothing. That article of clothing, like I said, can be a shoe. It can be an actual piece of clothing. You see the 7 here is the exterior surface. Let me see here. And that exterior surface 7 here has that machine readable identifier. Then you essentially scan it. That's what it's saying. And that second step, receiving a scan of that identifier to detect ciphers at each predetermined discrete areas. And then you're going to process that scan to extract an encryption key. So it has an encryption key each article that's pretty much showing whether or not it's a fake or not. Then you processing that scan, and then you accessing a digital token that's associated with that encryption key, and then you authenticate it. So again, that's pretty much what Nike is doing. And it's actually a pretty good claim here. This method claim is a pretty good claim by Nike. Pretty solid claim. So you see the Cloud 36, you see a hard drive. See your boy wearing the Nikes. Got the database, got the whole system, third-party integration. See that machine readable identifier. Symbols, colors, or geometric shapes. So again, man, ultimately, this is an L for anybody who's trying to sell fake Nikes. Anybody who's trying to sell fake Nikes. And they even got them on the sole, which I think is pretty cool. So not only is this, you can have it in the swoosh logo or the Nike word, but you can also have it in the sole. So you're essentially taking your phone and in different areas of the shoe to authenticate it, to make sure it's a real shoe that was actually issued by Nike. So, man, shouts out to Nike on this one. I think this is a big technology. I think you're going to start seeing more of this type of stuff, and it's only the beginning for Nike. So they just actually got a patent on it late last year in December of 2025. So, man, to the extent that you guys are trying to sell fake Nikes, looking like your time is coming to an end as we kind of move on here. Now, I do want to, this is a law firm fight, and this was actually interesting. I'm going to pull up the article, and we're going to read it. It's a short lawsuit, but this was actually 2 law firms in the Michigan area, not only in the Michigan area, and I think in the Detroit metro area. So let's kind of pull up what these law firms, and this is what you don't want to do. Let me kind of stop sharing the screen. See if I can stop sharing the screen. Let's see the Chrome tab, man. Is this? There we go. Hit that like button for the YouTube algorithm, as well as hit that subscribe button as we pull up this first lawsuit. We're gonna do 2 lawsuits today. This is gonna be the first one. This is a quick one, but it's interesting for a number of reasons. So it's what? Elamitics versus Off the Record. Anytime you see PLLC, them law firms. So let's go through it here. This is a complaint for trademark infringement, amongst other things. Defendant without authorization. So Elamitics is the plaintiff, and the defendant is, who's the defendant? Off the Record. That sounds like a record company. We're going to skip the jurisdiction and venue. Let's go to the factual background. So Elamitics is a Michigan law firm, obviously legal services to consumers. They're doing DUIs, license suspensions, license restoration matters, and related motor vehicle offenses. Elamite offers its legal services throughout Michigan, including the Metro Detroit area. That's where I'm located. That's their website, elamitics.com. Pretty unique name. So the plaintiff is the owner of a valuable trademark and common law rights. Look, anytime you start throwing common law rights in there, that lets me know you don't have a federally registered trademark. And I want to bring this up for a number of reasons. You can sue somebody even though you don't have a federally registered trademark. So in other words, you can actually use a name of your business, in this case, Elamatics. You can never get the name trademark. You can technically sue somebody for trademark infringement based on your common law rights. I'm not going to go through what common law rights means. However, I do want to say that I don't recommend you doing this. I recommend you first getting a trademark and a registered trademark with the United States Patent and Trademark Office before you sue somebody. Because if you try to, it's almost like you telling your people you done made the team, your sports team, say you in high school, you trying out for the basketball team, the football team, whatever the case may be. You going around telling people that, hey man, I done made the team before you actually made the team. When you register your trademark with the USPTO, it goes through an examination process. So when your trademark gets issued or registered, it's, you feel pretty good because you have a registered trademark. However, when you don't do that and you use a name, you get these common law rights, and then you try to sue somebody in federal court for trademark infringement, they may come to the judge in the court may come to the conclusion that you don't have an actual trademark. And that's kind of weird that this law firm did that. I'm telling y'all think law firms and attorneys, they smarter than the next people. A lot of times they not that smart. And again, I don't want to kind of rip on any attorney, but I think this is crazy to have a law firm name that you don't get trademarked until you got to sue somebody. I get it, you can do it, but the USPTO may come back and say, hey, you can't get a trademark. And if that's the case, if that's the ruling, then you're really screwed because you done lost money in a lawsuit, and other people can use your name without you being able to sue them in a lot of cases. So that's weird to me that in this case, this attorney decided not to register his name. He actually just he just actually filed for a trademark application with the USPTO. Again, you can sue somebody based on your common law rights. However, if the USPTO decides that you don't have a trademark, or the courts decide that you don't have a trademark, then you are essentially pretty much screwed. So when somebody gets to talking about common law rights, I know they don't have a USPTO trademark, or a federally registered trademark, I should say. So a plaintiff is the owner of a valuable trademark and common law rights in the mark Elamatics, which plaintiff used connection with, so forth and so on. Plaintiff have been using it since 2015. They've continued to use it, so forth and so on. Let's go to the defendant activity. Subsequent to plaintiff's use of Elamatics. So again, Elamatics is a weird name, but it's a law firm here in the Detroit metro area with the actual knowledge of plaintiff rights and in use of the word, and with the intent to misrepresent the source of defendant services. So the defendant, off the record, which sounds like a record company, we're going to put that to the side. The defendant adopted and is using Elamatics in or confusing similar imitation thereof, including photographs of its principal in connection with the advertising, marketing, sale, so forth and so on. This is another law firm. Upon information of belief, off the record has used Elamatics and photographs of its principal in a manner calculated to cause confusion. Off the record has no consent, license, or other authorization to use the word mark. And off the record continue to use it after being placed on actual notice. Yeah, man, if you send somebody a cease and desist letter, you don't have an actual trademark, they really gonna disregard that. I'm gonna tell you that's how it's gonna work in practice. So, and it's crazy that the count one is a federal trademark infringement. You don't have a federal trademark. You can't commit federal trademark infringement if you don't have a federal trademark. Let's see what they say nonetheless. Off the record, use of Elamatics and the colorable imitations thereof is likely to cause confusion. The plaintiff demands that the defendant refrain from using the word and or confusingly similar imitations thereof, including the photographs of its principal. Despite defendant's prior knowledge of plaintiff's right, defendant without consent has used and continues to use the mark. Defendant's use of the mark constitutes willful infringement, so forth and so on. Like I said, you can't. I don't know, man. It's crazy that attorneys are suing other attorneys for federal trademark infringement when they actually don't have a federal trademark. But we'll see how that plays out. Like I said, the plaintiff actually just filed for a trademark application recently. We even see if they get a federal trademark application. it may come back that they can't even register the term. So we can keep that in mind as we go off to the really the big lawsuit of the week. TikTok has been sued. And I do want to bring it on myself, because I think I talked about this. I can't remember. I didn't go back and check. But it's a company called Ticket. It's pronounced Ticket anyway. The spelling is a little weird. It's a software as a service company. And I think TikTok had sued them for trademark infringement. But Ticket, the company, they actually got a trademark, or not got a trademark, but the USPTO, United States Patent and Trademark Office, said they can actually register the term ticket. So I think TikTok I think they not in a great position, me personally, and we'll see as I read through the lawsuit. But essentially, TikTok sent them a cease and desist letter. They said, no, we're going to continue to use this word ticket. You guys let me know, does ticket and TikTok, is that a likelihood of confusion? Do you think the term ticket is a likelihood of confusion with TikTok? I don't think so personally, but two reasonable minds can differ. So you guys have to let me know that in the comment section as we pull up this lawsuit. I'm giving you guys a breakdown. So Ticket is using this word for their business. TikTok is sending them a couple cease and desist letters. Ticket is like, man, we don't care what y'all talking about. We're going to use this. Ticket actually filed for a trademark application. Unlike the law firms, Ticket filed for a trademark application with the United States Patent and Trademark Office, in which the Patent and Trademark Office said, okay, you can get a trademark on this, which really looks good on Ticket in terms of the plaintiff in this case. But TikTok, what do? They started to kind of fall back. Really, I think TikTok thought that they can bully Ticket, and Ticket wasn't going for it. And ultimately, what Ticket is doing now, which is the content of this lawsuit, they filed for what we call a declaratory judgment to say, hey, court, please tell TikTok that our name is not committed trademark infringement against their name. So they're essentially going to the court and saying, hey, we want y'all to decide here. We're going to get out in front of this. We're not going to let TikTok try to bully us. We want y'all to, the USPTO already said we can register this mark as a trademark. So we want the court to tell TikTok essentially that this is not trademark infringement. So that's essentially where we're going to pick up from. Kind of pull this up, man. Hit that like button for the YouTube algorithm, as well as hit that subscribe button to be a part of the IP community as I'm pulling this up. Let's go. So Ticket is spelled T-I-K-T. It's suing TikTok and all their affiliates. I told you a declaration of non-infringement of the trademark, and a lot of people can do this, man. People don't know. When somebody is threatening you with a trademark lawsuit, if you feel that comfortable and that confident, you can actually go to the court. You can sue them and go to the court and say, hey, court, tell them, essentially, this is what it's doing. A declaration of non-infringement is saying, hey, court, tell them that we are not committing trademark infringement. And it happens all the time. So Ticket is a Connecticut LLC that owns and operates a website located at essentially ticket.com. The website provides image downloading and video downloading services to its users. Within certain generations, users restrictions, these services are free to the public, so you get some of them for free, some of the services for free. The website allows users to download individual electronic images, image galleries, video recordings, and similar digital media from virtually any image hosting site as it expressly advertised on the website. The website is a so-called universal downloader that permits the downloading of publicly available video files, audio recordings, MP3, MP4 files, and other images not protected by digital rights management tools. In connection with the providing of the services through its website, Ticket makes the use of the trademark Ticket, T-I-K-T, as in ticket. On or about June of last year, Ticket filed an application to register the trademark. So this is what I was telling you guys. They filed with the USPTO a trademark application. The application seeks to register the mark for use in connection with the software as a service, featuring software for format shifting, downloading, and transferring images, image galleries, and collections. On or about January of this year, TikTok sent a cease and desist letter to Ticket claiming that Ticket trademark infringes upon and dilutes TikTok trademark and demanding that Ticket stop all use of the Ticket mark and withdraw the pending application to register the Ticket mark. Ticket thus faces a pressing, vital business decision, whether to surrender and abandon its trademark rights in the Ticket mark and fundamentally change its business identity, or instead continue using its trademark and prosecuting its trademark application under the threat of TikTok enforcement activities. This is precisely the limit intended to be remedied by the declaratory judgment. So again, essentially what Ticket is saying to the court is, hey, we filed our trademark application with the United States Patent and Trademark Office. The United States Patent and Trademark Office said that, hey, we can register our trademark. In other words, they're saying, hey, our trademark is not similar or confusingly similar to TikTok's. And you guys have to let me know, do you think TikTok and Ticket is a confusingly similar brand? I don't think so. However, TikTok is sending them cease and desist letter. Seems like earlier this year, last month, they just sent another cease and desist letter to a Ticket. And Ticket is like, hey, let's take this we're going to get out in front of this and let the court decide ultimately. So, I mean, I like that. I like that. Let's continue reading. By this action, Ticket seeks a declaration that its Ticket trademark does not infringe TikTok's trademark. It does not dilute TikTok trademark. So we're going to skip the parties here, as well as the jurisdiction and venue, and go down to the facts. So since at least earlier 2025, Ticket has made commercial use of the trademark Ticket in the U.S. in connection with providing software as a service, SaaS, featuring software for short format shifting, downloading, and transferring image galleries. So they've been around for just over a year, or not even over a year. On or about June, they filed the USPTO, with the USPTO a trademark application. Following examination, I told you, from the USPTO got preliminary approval in the form of notice of publication stating that the Ticket mark appears to be entitled to a registration. Late last year, December 31st, so the last day of the year, Ticket requested and received from the Trademark Trial and Appeal Board a 30-day extension of time in which to oppose the registration of the 557 application. Earlier this month, on February 2nd, 2026, Ticket requested another extension, this time a 60-day extension to oppose the registration. So Ticket, this is the day before my birthday. My birthday is April 2nd. The irony of they added to April Fools to file a formal notice of the opposition. So what is going on, David? So essentially, TikTok, when you file it's two ways to go about this. So it looked like TikTok did not file a formal complaint in federal court. What happens is Ticket filed for a trademark application. Ticket, it seems like they filed a notice, an intent to use application in which it was granted. They got a notice of allowance. And then it seems like TikTok filed an opposition with the TTAB, the Trademark Trial and Appeal Board. And it seems like they had an initial extension, and then they just got another extension in which they got to file a formal opposition by April 1st. Seems like what TikTok was trying to do, they filed that opposition, and it seems like they're trying to essentially force, or I don't want to say bully, but they're trying to force Ticket to stop, to withdraw their trademark application and stop using a Ticket mark. Ticket, like, no, we're not doing that. If you want to come after us, you're going to have to sue us. Again, TikTok, they didn't sue them in federal court. They filed an opposition to the trademark with the TTAB at the USPTO. And Ticket was like, look, man, if y'all not going to sue us, then we're going to sue y'all and let the court decide this stuff. This is interesting. Because if to be honest with you, if TikTok would have filed that TTAB lawsuit or filed a formal opposition with the TikTok, Ticket would have never been able to get in federal court. They probably would have been able to file a motion, but it probably would have been stayed pending this whole this TTAB ruling. But it seems like Ticket got out in front of it and said, okay, if y'all not going to file no formal opposition, then we're going to get y'all in federal court so that the judge can say that it's not trademark infringement. And now, if the judge at the federal court level tells that it's not trademark infringement, then, the TTAB, their hands going to be tied at that point. So this is very interesting strategy of what Ticket is doing in this case. Hopefully you guys are picking up what I'm putting down. So on January 8th, TikTok sent the cease and desist letter. I told y'all, TikTok, they filed the opposition December 31st. Then they sent the cease and desist letter to Ticket to say, hey, withdraw your application, withdraw the 557 application to stop using of the Ticket mark and any variation thereof. So they're essentially trying to big dog them. So the allegation, claims, and demands made in the demand letter are unfounded, inaccurate, overbroad, and have no basis in law or equity. So the Ticket mark does not infringe the TikTok mark. And I would probably agree with them in my opinion. So there is no likelihood of confusion created or caused by the simultaneous commercial use of the TikTok mark and the Ticket mark and the TikTok mark on the respective goods and services. tickets, commercial use of the ticket mark also does not dilute, or again, I just would agree with them. Let me know what y'all think in the comment section. So the declaration of non-infringement, this is the count one that we're probably going to read. So based on the facts set forth in the foregoing allegations and actual controversy now exists between ticket and defendants regarding the issue of whether the ticket use and registration of the trademark ticket in connection with the providing SaaS infringes on TikTok mark. So again, when you file for a declaratory judgment on non-infringement, you have to obviously allege that an actual controversy exists. And I would probably say a controversy exists if TikTok is essentially filing a TTAB, or they filed a notice at the TTAB for opposition. Absent a judicial resolution of this matter, ticket will be uncertain as to whether its continued use and registration of the ticket mark will expose ticket to liability. Under the circumstances, a judicial declaration is necessary and appropriate at this time in order that the ticket may determine its rights and duties under the Lanham Act or other applicable law, the facts of this case. We're not going to read the other accounts, which will have a no fair competition as well as a dilution of the trademark. And this is interesting stuff. And this is why I tell you, on one end, the USPTO is saying, ticket, y'all can register your mark. At least an examining attorney is saying this. Now, TikTok has filed an opposition. They didn't file a formal complaint, but they filed a notice to oppose the mark. But they keep getting these extensions. I think they're trying to get the extensions, in my opinion, to try to force Ticket to withdraw the application and stop using the mark. And I think Ticket, them as well as their counsel, knew what TikTok was trying to do and said, no, we're not going to do this. Not only is we not going to stop using a mark, we're going to get out in front of this and file a declaration of non-infringement with the courts, with the federal courts. So we'll see what the federal courts say. If I had to guess, I don't think this is trademark infringement. Let me know what you guys think. This is some gamesmanship on both parties between TikTok filing that notice of opposition, but not filing a formal complaint, and instead trying to send cease and desist letters to see if Ticket would just withdraw the application. Ticket not only did not do that, but they filed for a trademark, or they filed for a declaration of non-infringement in federal court. So again, I don't think that TikTok is going to win in this case. Personally, I think Ticket and TikTok is no trademark infringement or no likelihood of confusion. So I think TikTok also ultimately is going to they're going to come out on the wrong end of this. But again, that's a win for the little guy to know that you can go up against a behemoth such as TikTok and still potentially have success. So let me know what you guys think. I think that's pretty much the end of it here. We made it through another one, man. We made it through another one. Again, man, go check out the ebook, Got IP, as well as kind of be on the lookout with more information to the Trapdoor calendar. So hopefully you guys enjoyed this one. Hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community, and make sure you are protecting that intellectual property, whether it's books, whether it's copyrights, whether it's trademarks, whether it's patents, trade secrets, your right of publicity. NIL is a big thing, whether it's NIL. Make sure you're protecting your trademark, and catch you guys on the next one. You guys take care. Peace.